Notice of the December 5th and 6th, 2018 meeting of the Board of Architectural and Engineering Examiners was posted to the Board of Architectural and Engineering Examiners website on November 28th, 2018. We will now call this meeting to order. I guess Wanda will
I can hopefully go ahead and do that.
do a roll call.
Yes. Switch to, okay. Ricky Versailles,
Here.
Stephen King.
Here.
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 Robert Campbell.
Here.
And Mr. Alton, he is not here. Thank you. You're ready to go.
Great, and we want to introduce our guest here. Chris, you want to? Sure. Here.
Chris Walker here.
Perfect. Alton can give us an official here.
Here, officially.
Okay. And we want to welcome Ashley Gino here for the Engineer Committee meeting. Ashley will be our attorney for the board in our meeting, and welcome. Thanks for your help.
Thank you.
Okay. We have some, I will say, we've got some audits, some applications to discuss, 3 of those, and then Roxana has given us the items for discussion that we have for the meeting. There are 6 items on here, and I will add to that this meeting, I would propose that we elect a new chair for this committee. It seems like this has been a 1-year deal. Is that, in my memory, correct?
Acclamation, I think.
Is there any issue with reappointing the same? I make a motion that we reappoint Ricky Versailles as the chairman of this committee.
Well, we can second if you want to, but historically, we have rotated it.
Well,
historically, it's usually has been a 1-year deal.
Since when did you ever conform or comply with historical
I'm a big fan of tradition.
I love tradition in this case too, but and what I'm thinking is that I have done it for a little more than a year. When Laura left, I assumed the chair, and it seems like it's a kind of a nice time if I handle this meeting. Then the new year would start off with a new committee chair, and we can maybe keep track that way. So be thinking about it. We'll get maybe some nominations and take a vote today. So
Good idea.
okay. All right. First up, though, why don't we look at these applications? And I've got one I'm ready to talk about, the Martin Velasquez. If we're ready to discuss that, I reviewed that case, and this is an applicant with a foreign degree, and the applicant was deficient in 7 hours in general education, which was not a problem. Had, from our worksheet, had credit from a master's degree and from working here in the country, so that was made up. My question in reviewing that is when I look at the NCEES evaluation of the foreign degree, the math and science used courses from the master's degree to make up that 32 hours that it's looking for there, and then under the engineering hours where you're looking for 48. Four courses, again, from the master's degree to make up that 48 hours. And I just don't remember us dealing with that before, where some of the master's courses were plugged into the the evaluation for the basically a bachelor's degree, but that was my only hang up is I didn't want to approve something that we'd never done before, and I couldn't remember it, so I thought we would bring it up, and I'm wanting to hear from others.
Just a question. It was my understanding that NCAAS approved that. Basis.
Thank you.
Do we have some basis for refuting their judgment on that?
I don't necessarily, but I know that everything that NCES may approve, we don't necessarily approve of, like an engineering technology degree, or we're not okay having a biology bachelor's and an engineering master's. So I didn't know I just didn't have any history on this, and I'm pretty comfortable with approving it, but I didn't want to just approve it for the first time without asking.
The only reason I could think of that we wouldn't approve it is if the individual was using the master's degree and 3 years of experience, and it doesn't look like that's the case. So,
correct.
I would think that's okay, and I think we've done that before.
That was my rationale too, Ricky, when I did approve it, was that we've used, whether it's a master's level course or whether it's a course that they're required to go take at another university or whatever that we've used, we don't really mandate that it has to come from specific sources. And so those courses can be used just as if they were to go out and take a science class at a community college or something that we would sign as deficiency. So that's why I went ahead, and to me, it's the same difference that we have there. But that's a good question to see about, because they did have their BS. They were just, it was a foreign degree BS that was deficient. Yeah.
And that's a good point. We do let them, if they're short somewhere, just take a course somewhere. So, okay, are there any other comments? Okay, well, why don't we hear a motion to approve this applicant?
I'll move to approve this applicant.
Okay, second.
I'll second.
Okay, all in favor? Aye. Okay, passes. All right, let's move on to Schumacher.
All right, Schumacher basically has passed the exams, both the fundamentals and the professional exam, in Illinois. And I guess I didn't quite understand this, so let me make sure that I state this correctly. Staff, correct me if wrong. He wants to apply to the Tennessee board by exam and accept his scores from the tests that he took in Illinois. However, he isn't registered in Illinois. Is that correct? So previously what we have required is that for a COMITE application he become registered in another state in which he took the exams, and then he apply for COMITE on the basis of his equivalent registration. So I guess the question is that still the interpretation, Ashley, of what he must do? Sorry, but you're listed here as the de facto expert on the issue.
She is. She's
I'm sure she is.
Okay, because this person does not have a license in another state, as far as I am aware, he can't apply through COMITE because COMITE and reciprocity is only for people that already have
They're
a
licensed
license
in another state.
Right.
Right.
So I believe what he has done here is applied through the exam application. I have found no rule that would prohibit him from filing an application by exam, even though he took his exam in a different state. However, when he applies through the exam application, he has to meet the requirements of TCA 622401.
All he did was fill out the app. Is that right?
He hasn't actually applied yet.
Oh, okay. All right. So
This is just for you all to look at and make a determination of whether we're going to keep the same policy we've been doing the past couple of years or go back to where it was before.
So the problem seems to me to be he graduated in 2013, he passed the exam in 2015, which would not be 4 years of experience from the time he graduated to the time he passed his exam. So he would be a decoupling person.
Oh, okay, well, I'm glad
so-
you added all that. I didn't
Yeah,
understand all that.
so what happens is we've talked about,
He does have a
since,
master's degree.
right, but our statute says that you have to have 4 years' experience, right, progressive experience after passing the fundamentals or after graduation before, and then you take the test. My understanding is the statute is ordered when it comes to an exam applicant. So an exam applicant has to go graduation, test, or something like that, 4 years experience, or, excuse me, I lied. Graduation, 4 years experience, then test, because it is in a specific order in the statute. But in comity, it just says you have to have those three elements, and it doesn't give an order to them. So I think that's where we came down was, in order to be considered as an exam, you have to do it in order. And obviously, we're still fighting that fight or having that discussion as far as our people. But so to me, they still have to. I think you're right. I think they have to get registered in their state and then apply for comity. Is what we've always understood. So go ahead.
Fill the floor.
I would just like to point out that with the reciprocity statute, which is Tennessee Code Annotated 62-2304, Portion A, which is what specifically applies to engineers, it does provide, and I'll read it to you so you have it. The board may, upon proper application for a certificate of registration, issue a certificate of registration as an architect, engineer, registered interior designer, or landscape architect to any person who holds a like unexpired certificate of qualification or registration issued to the person by any state, territory, or possession of the United States or of any country, provided that the applicant's qualifications meet the requirements of this chapter and the rules established by the board. And then it goes on to say any applicant for registration as an architect or landscape architect pursuant to this section shall hold an unexpired national certificate issued by the National Council of Architectural Registration Boards or the Council of Landscape Architectural Registration Boards and shall present proof of the certificate upon application to the board. And I point this out to the committee to really point out the second part, which said provided that the applicant's qualifications meet the requirements of this chapter. Yes, that's reciprocity. So,
What does the one say about examination? That's
that is 62-2401, and that provides A, the following shall be considered as minimum evidence satisfactory to the board that the applicant is qualified for registration as an engineer. Part 1 provides graduation from approved engineering curriculum, experience and examination, a graduate of an engineering curriculum of 4 years or more, approved by the board as being of satisfactory standing, and with a specific record of 4 years or more of progressive experience on engineering projects of a grade and character that indicates to the board that the applicant may be competent to practice engineering and pass an examination prepared by the National Council of Examiners for Engineering and Surveying involving the fundamentals of engineering shall be admitted to an examination prepared by the National Council of Examiners for Engineering and Surveying in the principles and practice of engineering. Upon passing the examination, the applicant shall be granted a certificate of registration to practice engineering in this state, provided that the applicant is otherwise qualified.
But it did say education, and then it said 4 years, and then they can take the test. I mean, that's what we had always talked about. That order had to be for an exam candidate. For a comedy candidate, it doesn't have to be in order. Is my understanding.
This person has the requisite experience post-graduation if we include the year allocation. They would have 4.5 years with the master's.
He graduated bachelor's degree, got his master's, and it's been 3 years plus since he got his master's.
3 years, 5 months.
So he's got 4 years, 5 equivalent experience.
Right.
He didn't pass it, but he passed. It's not 2019 yet. No, it
Oh,
does.
from 15, 16, 17, 18,
Plus the masters.
plus the masters. So he gets a year's credit for the masters. So it's 4+ years.
So but he didn't take the test. He didn't get 4 years' experience before he took the test, though.
Now, he took the test in 15.
That's what I'm saying.
No, we're just talking about, does he have the requisite
Right,
experience?
right, yeah.
Not the order,
Not the
but
order.
he does have the 4+ years' experience.
Yeah.
Yeah.
So it seems to me, I mean, because we've had this situation with somebody that took it in Kentucky under the decoupled statute where they only had 2 years' experience, and we've all told them in the past that they had to get licensed in Kentucky before they could come and become licensed in Tennessee, and they had 4-year experience mark before they could be licensed in Tennessee. And it seems like our statute says that very thing. So,
All in line with perfect timing as far as the decoupling conversations and the research sort of that Ashley's already. Really no reason to change it, but he happened to come just at the time where we've got a new attorney. We kind of had to think it all through again and make sure we're on the same plane. I don't think the statute gives you any leeway. Ashley mentioned, so he either gets a license in his state and comes in through comedy, or he can retest again, right? I mean, that's an option to him that I think we can pose. Not that anyone would want to take the PE exam, but that would be at his discretion because all that experience otherwise in time lost.
He does have his license in another state.
Not yet. No.
Oh, I thought it said he
That's
passed
the
it.
whole. That's the whole.
This is, so the problem is, this is the initial license that this
Ooh.
person would be getting, and we're saying because of that distinction, he really has to meet the rules, not under comedy. He's got to meet the rules under, for the test taking.
Agreed. Yeah, I agree.
And so that would be the message.
Ashley, is it your opinion then that it has to be done in that order? Because I could see, it didn't specifically say that, it indicates that, but, so is that your opinion?
Legal's position is that if you are applying by exam through that Tennessee Code annotated 622401, Section A1, which I read to y'all, that you would have to follow the exact order as laid out in the statute.
Kind of makes sense. I mean, besides the legal interpretation that they say you have to have these things before you can apply for the test.
It makes some degree of sense, but the bottom line's the same. If they took the test, they've got the experience, it really doesn't matter. They've met, the public's protected, is my point, I guess. So, it just boils down to, I guess this description indicated that we may have had a different interpretation from a previous attorney, so I just wanted to make sure that was.
And I think it
her
was, not with
interpretation
Liz, even prior to Liz. So we thought it was a good time to have the conversation for you all to review it. Decoupling's being discussed. We've got some research, and make sure that Ashley agreed with us, and she did, that you're doing it right.
Okay. So do we need to vote on this, or is that enough guidance on this, or?
We don't get to vote on it. From what I
It's a
understand,
legal
she's
question.
saying no.
Well, I mean,
Is that correct?
Right, and it's not just, again, I think we've gone back at least two different, I mean, this goes back a pretty good period of time when decoupling started being talked about in the, and Steve, I understand the sentiment of it, but if we take that stance, we've basically decoupled our statute. I mean, if we take that stance.
Might not be a bad thing.
It may not be, but I'm just saying that we don't have any,
Right.
because then somebody could have taken it 1 year and they could come in after 4 years' experience and say, oh, well, you passed it for that person, so you've basically decoupled. And while I agree with you, we're protecting the health, safety, and welfare, from a statute standpoint, I think we're going to be in violation. And that's not going, but actually it's going by like a couple different, I mean, it goes all the way back to.
I guess my only point is licensing is constantly attacked, and we need to fight for what's really important, not just if that's, it needs to be fixed, I guess, is my point. Like when a master's degree candidate wants their license and they go to a legislator and pitch a fit and get something that we don't necessarily think is a good thing and protects the public. This is just the kind of thing that's, at least in my opinion, not really serious as far as protecting the public. And I'm not suggesting we violate the advice of our attorney, but this is the kind of thing that we get attacked for, that we don't even need to fight this battle. I mean, there's a lot of battles we want to fight, but this isn't one.
So your statement is just in support really of decoupling, right?
I think we're going to see more and more of this, and it's going to get embarrassing, and at some point somebody will get mad enough that to go a different route to try to get it fixed.
One comment I'll make, test my memory here since we're right here at it, is that that passage about comedy that you read, Ashley, under comedy, where we say that we will accept this applicant under comedy. So basically, somebody could come from a decoupled state, and we would accept them. Yet, at one point, when I first got on the board, we did not used to accept these applicants who were decoupled. And then we had a legal ruling that what is read under comedy really doesn't have that same language about the order of things. Even though it has the statement that provided the applicant's qualifications meet the requirements of this chapter. I mean, in my mind, somebody could interpret that to say you need the requirements of this chapter, or you have this order you got to meet. But the ruling was it doesn't. So we started accepting decoupled comedy applicants who come from a decoupled state. Is my memory correct?
Comedy gives you some wiggle room. Reciprocity in general just gives the board some authority to look at the whole picture a little bit.
Casey, why don't you came in at just a bit, why don't you introduce yourself? And
Casey Anderson, Executive Director.
it wasn't really the topic, but it's just we were right on that passage there and talking about it. And anyway, that's changed over the years. This is the way I remember it.
Austin, were you want to?
Yeah, just for clarification's sake, actually, the passage that you read about comedy was 622304, is that correct? And I think the intent of that is to generally apply to all of the four, even though it says specifically architect, right?
As architect, engineer.
Well, I'm looking over on B.
Oh, okay.
B, as far as I can tell, only applies to architects. It does not apply to engineers or interior designers.
So under the registration requirements, qualifications and registration for engineers, Part 4, there's really no mention of comity application. So I suppose I would assume that 622304 is universally applicable then? It says general. I mean, it's qualification and registration generally. Correct? So even though it specifically says architect, the intent is for it to be applicable to all of our disciplines.
Are you talking about section B?
I'm talking about section 62-2-304, comity. And it's under the qualifications and registrations generally.
Where do you see those
What
words?
page number on the iPad?
8, I don't know on the iPad, I'm looking at the,
It's a little notebook that you gave us.
I think I understand what you're asking. The way that the legal division reads 62-2-304, and I did discuss this with Tony, our chief counsel, as well. We read Section A as applying to architects, engineers, registered interior designers,
Says that in
and
there.
landscape architects. And then we read Section B to apply only to architects. Is that it's Section B? Section B only mentions architects in it.
And it only mentions NCARB there when it references the board. 11, page 11. Is that what you're looking at, Alan? Page, are you looking at 62-2-304?
comity, correct.
A and B?
Well,
Okay.
now, Part A applies to all of our members. Part B appears to apply specifically to architects.
That is correct.
So, under A, under A, in essence, they have to specifically follow the rules and regulations of this board in order to be eligible to apply. And based on what you'd read previously, because they didn't go in the appropriate order, they didn't get the 4 years of progressive experience and then sit for the PE, they don't technically comply with our rules and regulations.
For comedy applications.
Correct.
Yeah, that would be correct.
Okay. And they couldn't apply by comedy because they're not registered anyway, correct?
Right. This particular individual, is my understanding that he's not licensed in any state right now.
But he wants to become licensed in Tennessee, and in order to become licensed in Tennessee, he has to have followed whether we agree with him or not, he has to have followed the rules and regulations that are established in this document. And he has not technically followed those rules and regulations, correct?
Based on the information that I have regarding this particular applicant, it appears he did not follow the order that is listed out specifically.
I agree with that. Okay.
And that's the order that's in
62-401.
order for somebody trying to establish their first registration. Okay. All right, so we don't need a vote. It's the law has been stated and explained to us, so that tells Wanda how to answer.
Okay, so I need to tell him I need to tell him that he needs to apply.
Or take
He
the
needs- he
exam
needs-
again.
I know he's not going to want to do that.
That is his discretion, yeah.
He would be
Yeah.
eligible to
He
sit
needs
for
to
the
get
exam.
registered in Illinois and then apply here by comedy.
Right.
Okay.
Yes.
And tell him, with deep regret, we must inform you that, because it's just silly.
And many other states that are looking at decoupling are probably facing something similar. In their statute, they've got a certain set of steps they must follow. If we determine that we're ready to address that and change that, that's where we'll have to start, is with.
I don't mean that decoupling is silly. I don't mean to be on the
Right,
record
right.
as
No, I
saying
get
that.
you.
It feels like in this instance that
He's qualified
he's
otherwise.
done all the things
Yeah.
he needs to do, and we would accept him for registration if but, and that's just on the advice of the attorney with regard to an interpretation of the law. That's just the way it is.
So, definitely, I mean, what you all just said is fine. But keep in mind, too, that this phenomenon we call decoupling has really only come to our doors in the last 2 to 3 years. I mean, before it was Nevada, and that was about the only state that was decoupled. So, at some point, this hasn't been a big deal. And then it's Kentucky and South Carolina. And again, everybody knows our position that I think we're ambivalent one way or the other, but I don't think we can spearhead a drive to get stuff done. And that has to come from and they have to have more than 51% of the people driving that train, or it's going to get hung up in a fight somewhere, and then it ends up being worse situation than what you just mentioned. So we understand the frustration, but we're kind of dealt the hand that we've got right now. So as the golfers say, we're playing it as it lies, so we have to do that.
No lift, clean. Tiger always called it lift, clean, and cheat.
Left clean and cheap.
Yeah.
Of course.
All right, let's,
Just for clarification, I'm sorry, just for our own information, Casey, are there 21 states now that have passed decoupling?
Sorry, the recorder asked me to speak into a microphone. So, since I didn't, Casey Anderson with the Engineering Societies. The last number I can recall was 21 or 22. NSPE has just finished the research on all of that. Sorry, and I need to pull that anyway, so I'll go ahead and pull that for you. And if I don't have it during this meeting, I will have it for you tomorrow with that answer. And just as an update from our end on what's happening, we have got a committee together, and I have frankly just not had time to sit them down because we've had some other huge things come up. But are planning to put that committee together, everybody, have our first sort of formal meeting in the next, probably within the month. That's my hope anyway. But my goal in the back of my head, and what I've discussed with some legislators who are particularly interested in occupational and professional licensure, is that we're going to hopefully have some consensus and a piece of legislation to drop in 2020, the second year of this General Assembly.
Thank you.
That's the goal, and let's hope that no squeaky wheels interrupt the goal, because I think that would give us enough time to really flesh it out and understand.
But we don't have, I'm sorry, since the committee has not met, the professional organization has no stand on that issue right now.
So I'll tell you the truth. I think you put it up for a board vote on any given day, and depending on who's in the room, it goes one way or the other. The reality of the situation is you're going to have to make a phone call to one person who's not going to get a license in the state because of this block, which means that another person will come next month, and another will. This is officially a problem for the first time for us. In my opinion, in my recollection, this is the first time we've seen this happen, and we knew it was coming. So we're not going to be in a situation where the legislature is going to let that fly for very long. That is absolutely a barrier to practicing your profession in the state. So we're going to have to address it somehow. And I think the consensus is that people would prefer to have some sort of influence on what that looks like, versus having it shoved down their throat by non-professional engineers. So, so I think the conversation is different, whether you like it or don't like it. I think it's a different conversation starting now, because we've been sort of wondering if this would come or not come, but now that it has, I think we know that this particular person might not be the one who makes a phone call about it, but at some point they will.
This, in addition to being a barrier to licensure, it's also a barrier to commerce, because
Yes.
the reason these people are applying for licensure is to build Walmarts or Walgreens or subdivisions
Churches.
or whatever.
That was my point, but you said it a lot better than I did.
I don't know about that. I wouldn't rewind it and watch it again.
One other thing, just Roxana and I just experienced this, and Casey and I experienced it when we were passing out the certificates at the Middle Tennessee TSPE meeting. 3 times I've asked this question in group settings with engineers, and 3 times the response has been overwhelming. Just a very simple question. How many of you would have taken the PE if you were eligible to take the PE right out of college? And when I did it at that meeting, there was only one person that said they wouldn't, and the reason they said that they were afraid they may not have the appropriate experience, but the other 18 said it would have been easier, that it would have been better. When I did that at Tennessee Tech, there were about 45 students there, and 2 said they wouldn't. One because he wasn't going to need it. He was going into industry. And the other one's the same reason, he wasn't sure he would be fully qualified. And then at Lipscomb the other day, how many students were there? Probably 40 or so? Okay. And I think there were 3 there that said that they wouldn't take it. One of them was going into industry also, I believe, but the other 2 had different reasons for not taking it. But the overwhelming majority of the people that this is impacting would much prefer to take it right out of college. So far, I mean, it's the small sample size, but that's pretty.
Because they all think they'll pass, but they're wrong.
Well, actually,
A couple have
there's
good points.
information to the contrary. There's information to the contrary. I think you presented that, didn't you?
Oh, well, that's not what NCAAS told us last time, so that's what I was operating off.
The other piece of that is when you and I were doing the TSPE, handing out the new PE certificates to the Nashville group, we had 3 or 4 in there who worked for manufacturing, who had gone back and gotten their PE. So I was thrilled about that. And I think if the overwhelming, whether or not they're right to think that way is a different debate. But if it can encourage the folks who are going to go into non-traditional, consulting engineering or professional engineering at a public agency or whatever, into the manufacturing realm, if it's a method of encouraging licensure, I don't think it's that piece might be a secret bonus.
I'm in favor of decoupling, but when you said that, so Chris, can you tell us whatever it is that he's referring to? Is that in conflict with what we were told last?
Sorry, Roxanne, I
Sorry.
know we're probably off the agenda.
No, you're good. And actually, on your iPads in the material here, we've got the information on your 5 questions for decoupling. So Ricky's been kind of hitting the universities as well and asking around, and I think it's the right time.
Yeah, I've talked to probably 4 or 5 graduates from the last 2 years that have taken the test early, and all of them have passed. I don't know of any student that has taken it early from Lipscomb that has failed it. Now, they're not likely to come up and tell me that. So, I don't know, but
It could differ by discipline, too.
yes, these were all civils.
Yeah, I mean, I thought the mechanical test back when was pretty academic, but it may be that the civil test or some forms of it are more practice-oriented.
I think overwhelmingly, most people that take it would disagree. It's academic.
Okay.
The statistic quoted was it was still a 3 to 4 year sweet spot because
It was a
on
bell curve.
average, it's a bell curve.
It was a bell curve.
Yeah. So, and it was the nationwide statistic that talks about different things, and there's different things that influence it. Is how much of the reference material is used on the test. I think as civils, we probably have less total reference material than some of the other disciplines do. You have to deal with 4 or 5 reference type books instead of, or there's a standard for each that you go in, where others may have a lot more reference material. So I think that's part of the whole discussion as well. And I still think that NCAA statistic probably has some good validity to it, just because it's done on a pretty wide sample. But the other question to ask while we're talking about it is, it just goes to show that we don't have confidence in the test's ability to be the gatekeeper to determine competency for our engineers. If it's an academic test only and an academic exercise, then we need to. I tend to think that's a little short-sighted to say that. I don't think that's exactly accurate. But what we need to really focus on as a board, because I can't focus on what NCAAS does, is how serious we take that experience evaluation on these forms by practitioners. And we really need to beat the drum to our practitioners of how important it is to really vest themselves in that experience component of that. Because if the test doesn't matter and you graduate from a university, guess what's left? Experience. And if people just blow off the experience part and say, yeah, Sally or Joe's a good guy or good girl, and just sign those things and don't really get into that part of it, then there is no gatekeeper to the
I'll just a thought about that statement. Even though a test is academic mostly, I still don't think that that's without value. That there's some level of comfort I have that we've got some hurdle that requires somebody to be intelligent enough to pass a test, because not everybody passes the PE test, even if it's academic. And so if 65% pass and 35 don't, it still means something, I think, to me, that there's a test that people have to pass before they practice.
Right now, it's about a 48% pass rate.
So despite the fact that it's academic, there's still it says something, I think.
Where do you get that?
Look in the statistics when they publish who passes, how many took it, all the university data and information. I'm sorry, that's not university data and information, but when we get twice a year, I think, the information about the number of people who took the test and the number that passed, it always shows the results of, and then the percentage in Tennessee.
I just didn't remember seeing it at 48%, so I just want to go back and look at that and see what that says.
Anybody remember what the FE pass rate is? First time pass. I mean, I just wonder.
About 70%.
So there is some value, right? I mean, if again assuming that 48's right, that's 22%. Suppose the FE is a very academic test, and if we're saying the other one is an academic test, then there's a 22% gap in between the academics. Now, some of that can be attributed to time. You've forgotten stuff because it's 4 years later when you take the test. Some of it can be attributed to bad study habits that you've not practiced in 4 years. So there can be a lot of different reasons for that. But if it's going to be 70% of the people pass it, if they take it FE one day and the PE the next day, then that's a high pass rate that doesn't leave us a lot of this confidence in the test thing. I think at 48% there's some more confidence, but anyway, I think we need to have the conversation all around, and Kathy's helping them write test questions or something, aren't you? Good. I thought you were.
I was on that committee because I wanted to know more about it. I mean, it is very, very scientific, the way in which they go about writing the test questions. And I'd have to have all the data in front of me to share it with you, but I think there are anecdotal stories about how academic the test is that people repeat that have legs that aren't necessarily representative of the test data bank as a whole. And generally speaking, from what I saw and the people that I knew were writing test questions and the process by write the test questions and how they get vetted. Frankly, I thought it was kind of, I barely passed. That was 30 years ago, and I sure as heck wouldn't say, yeah, let me go take it again today. It's a tough, tough test, but I think that it is a fair test based on everything I saw. I don't think that it is only for PhD students. I think it is a fairly good representative inquiry as to your knowledge on the subject. And the people who are invested in preparing the test and getting it ready and putting it out there, they're in a whole different world than me. But when I looked at what they did, I had a lot of respect for that. And anecdotally, there's a lot of, well, there was a question and it was blah, 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 blah. Well, yeah, that's one question. That's one question. The bank of data questions that they have is like thousands. So there's always going to be the one or two that get out there that don't make any sense, and people cuss them and, say that it's just ridiculous. And why would they ask that question? That doesn't have anything to do with practice. But by and large, the PE exam and the people who are behind presenting that exam for the purpose of determining whether or not someone is minimally qualified, because that's the standard. That's the other thing to remember. This is not a test of, are you good? The PE exam is to establish minimally qualified. Minimally. That's a pretty low bar. So I do put a lot of street cred in people who pass the test, regardless of when they might pass the test. I think it's worth something. I don't think it's not a good process or not a good test. And statistically, man, if you go back and read all the stats on how many times they run a question and evaluate the answers before it becomes an official part of the test, man, I mean, there's a lot that goes into it. That's why it's insured. The data bank of questions is insured to the tune of like $6 million or something like that. I mean, it's a big number because the man hours that would be required to create that data bank, if it were to become hacked, if you will, is massive. That's how much work goes into it. So, I'm in favor of decoupling. I'm in favor of it. But the assumption that it'll make it, quote, easier for applicants to get registered, I think is a fallacy. I just don't think that's necessarily true. I don't see people passing it simply because they just graduated. So now they're going to be able to take an academic test and get registered. I just don't think that's going to happen. And I'm sure I'll be proven wrong many times.
It's good input. Your time on that committee helps us out because it gives us better right now. So thank you.
That's one more question.
Yes, sir.
If this person had done things in order in, was it Illinois, but did not actually get a license in Illinois, would they be able to apply to us, or do you have to get the license first in the state you took it in?
I think he would qualify. If he did it in the order, he wouldn't need to come in through comedy. We would.
Where I had heard an opinion that you had to get the license where you took the test.
It's education, experience.
So it's just the orders are running. Okay.
It's and the words say they have to pass an examination by NCEES, so whether it's in Illinois or Tennessee, it didn't seem like that would matter. Okay, well, Wanda, you've got to tell the applicant no, but you can say it spawned like 45 minutes of discussion. Whatever that's worth.
Right.
Okay, let's move on to Ward. Who did I give Ward to? Was that Kathy? Was that you? You, Steve. Okay.
This one's pretty simple. This gentleman has a technology degree, and he is really in an email asking us to use the I think he's misinterpreting that provision about the 12 years of experience. Because I don't know where he got that interpretation, but
FE There was a regulation that did allow for experience. I think that may have been removed now, but
Well, even though it didn't change the degree. What it changed was taking the FE.
Correct, that's correct.
And what he's asking is, he knows he's deficient. His technology degree is deficient by so many hours, according to Dr. Smith. But he's reading that provision to say that the degree doesn't matter. He's got the 12 years, and that's not what it says.
I'm just curious, like, in his memo to Wanda of October 22nd, which is page 3 of his app file that we have, he quotes, so what's he quoting? Is that actually out there somewhere that other people can misquote, where it says, or 12 years of experience? Basically, that's what he's highlighting.
A lot of people misread that. I don't know if it needs to be rewritten, but you don't know how many times somebody comes to me with that 12 years saying, well, if I have 12 years experience, it's saying it doesn't matter what my degree is.
And I agree with him. If it's actually written exactly the way that he quotes it.
It's not. It's in 62-2401, General Provisions, Part 2, Long Established Practice. It reads, a graduate of an approved engineering curriculum of
That's what I
4
read.
years or more
Right.
with a specific record of 12 years or more progressive experience in engineering project, integrate, blah, 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 would be eligible to sit for the exam.
Yeah, but I get that.
I think it would be clear, I know that we don't necessarily want to mess with laws if we don't have to because of what could happen, but in that case, I mean, it would be clear if it said 12 years in lieu of taking the fundamentals of engineering exam. It would be totally clear then, but you can come to that conclusion by reading it, reading the whole thing.
I think
so.
he's taken an excerpt from it to try to make a point, and I think we need to give clarification that
Yeah.
the full breadth of that, 62-2401, long established practice, says requirements that have graduated from a 4-year accredited university, and he failed to.
Of course, I told him that, but he's still.
Tell him the board's now telling him that. Well, I'm being presumptive. That's my opinion.
Because the 12-year thing is simply for people that did not pass their FE. That's the 12-year thing. You did pass, so you've got a waiver at the end of 12 years. That requirement is waived. That's all that's for.
Eligible to sit for and pass the PE.
I think both of you all turned it down, and I agree with that and would support that if you need a motion.
Do we need a motion? Okay. All right. Do I hear a motion?
I'd make that motion.
I'd second that.
Okay. So all in favor of denying the applicant, say aye.
Aye.
Mr. Ward, if I can add, because 2 board members had already denied him, so we're going back and forth, we will make sure in this particular case to get a letter from Ashley kind of stating the intent of that statute that he partitioned, so that we're not going back and forth.
Because he took the section
He
after what it
did,
said.
just a portion
right.
of it, and you
Right.
can always interpret a portion
I love
when you
parsers.
separate it, so.
And especially the first paragraph before it, it's like up here they describe the order with the FE, and in number 2 they describe the FE, the 12 years, so it makes sense. Okay, all right, that is all for the applications, unless there's another, Wanda, that catches up? Okay. All right, the second item on the agenda is applicant interviews. Do we have any?
Do not. We always have it there in case it's a last-minute
Okay.
thing, so we're covered. So I think on your iPads, and this time, especially for Alton, who was here late, he probably didn't hear me, you have a lot of documents. That's because with the QBS meeting tomorrow afternoon, they needed some documents. So I think if you would skip to letter B _ engineer items for discussion, we can start on the rest of the items. And this is some things that have already been sent to you all, some things that are new just for us, that had applied to the engineering committee only, that we can probably get ahead of and discuss. And some of these things included the decoupling.
Okay,
So.
good. Okay, so the first thing under that tab, if everybody,
But don't tell us where we are again, please.
B, under B,
B.
Engineering items for discussion.
Okay, all right.
okay, the first, page 1 of that is our reference for certification as an engineer intern, and that, from my memory and looking at my notes and then looking at what was sent to us before the meeting, it looks like the changes that we talked about at the last meeting have been implemented, where we used to require a signature of the dean or department head on that middle section for the senior students to be completed by the college or university. We used to require a signature, but now we're just requiring a printed name and an email address. And I think that makes our processing and getting that information quicker and easier, and we were all comfortable with that last meeting, and that we're just identifying who is vouching for the student there, not that it's a signature. So if we want to call somebody, we can. Is that sound like a correct statement of what's been done?
Yes, absolutely. And if everyone's comfortable with this and we don't want to tweak it anymore, then we would just need a motion to go ahead and update the website with the new form. We may send a quick note to the university saying, by the way, we've updated the form to simplify the process. It was voted on at the December meeting, and we will continue, because at the last meeting, I think we also touched on that the rule requires us to look at this, but we felt comfortable that unless the rules change, we are still looking at the division head or department head for that university as opposed to matching a signature.
Right. Okay, well, if we want to make a motion, and if we want to discuss it, we can do that after a motion in a second. We have a motion to approve.
I'll make a motion, we approve
Okay.
this reference
Do
form.
we have a second?
Second.
Okay, we've got a motion and a second. Now, any discussion about the form?
Just out of curiosity, Chris is here representing one of the engineering schools. I wouldn't think that any of the other engineering schools would have an issue with this, would they?
We don't believe so. I just recently, actually last week, I think it was from Vanderbilt, I got a list of, we just changed people, here's the new signature, and so I was very happy to say, and moving forward, you won't need to send us the signature image and all that. It'll be your department head who you trust and we can verify, and they were very thrilled. So periodically, Cindy will get these images of signatures in a panic, and then other universities probably think, they'll ask for it if they need it. They'll, it's a little bit of everything. I don't think they're going to mind this at all because we can follow up and make sure the name is part of the university and see the credentials.
I would think that, the due diligence is on our part, not on theirs now. It would simplify their process
Right,
a lot.
because we can go online and verify. It's rare that the university, within a week even of an interim person or dean taking over, we don't. That's easier than asking for an image of a signature.
Concern that I had.
Okay, any other discussion? Okay, all in favor of the motion, say aye. Aye. Opposed? Okay, form looks great. And hopefully that'll make Cindy happy.
We hope so. We do. And she did prove it and help put it together, so.
Please thank her
Definitions.
for that effort.
Definitely will. Definitely will.
Okay, the next thing that follows here, issue that follows, is the
Thank you.
definition of engineering topic. And we gathered here are a whole lot of definitions of engineering. Ashley, did you gather these?
I did.
Great. This is extremely helpful. I'm just flipping through, just summarize what we have. We've got all the states.
Are there only 4 that don't have less than 10, I know.
Yeah, I noted that Tennessee we are now lumped with California in something. California had no, how do you like that? I feel like we're so
That's
progressive.
cool, dude.
That's really progressive. So I will say that all of these states, and I know that we've charged Kathy with spearheading coming up with a first draft of definition of engineering last meeting, and this, I don't know if this is helpful to you.
Oh, this
to
is
have
hugely helpful, yeah. I'm sorry that I couldn't have done something with this before we came to the meeting. The intent was for Frank and I to get together, and they want a definition of architecture. Have they done anything on that?
They have not, and the only thing to remember is that you
I
can't
know,
work together.
I
But
know.
yeah, I know, I get it. But
We
no,
were
they
just
have
going to
not.
do hand signals.
Yeah.
We weren't really going to talk. But this is helpful, but I haven't done anything with it.
Okay, so go ahead, Robert.
No, I mean, why couldn't they get together? Because they're not making a decision. Because the Sunshine Law says if we collaborate to make a decision,
Make policy.
make
Is that what
policy,
it's
but
saying?
coming up with something that we're all going to vote on eventually and all going to see eventually doesn't seem like it comes to a conclusion to make a decision. It's just information that we need to have. That doesn't seem like that meets the threshold of what the Sunshine Law is, which is to deliberate to make a decision. So it's a question.
It's the legal division's position that when two board members meet to confer about anything that could potentially be a violation of the Public Meeting Act, if that meeting is not held available to the public and appropriately noticed so that the public could attend any such meeting between two board members, because you would be discussing like board business.
Okay, let me ask a question then. If Kathy wanted to work with Frank on definitions, and it was put out on the website, published that they were going to meet in this room a month from now, so that notice was given, is that enough? Is that okay?
Mini committee. I mean,
Yeah.
that's in essence, right now we're 5.
I
But
mean, I don't see that as a huge hurdle to schedule something in advance and
I do.
public notice.
Well, Frank's
To be able
not
to
here.
talk- And to be able to talk back and forth on the phone or say, hey, when you see the word consultation, what are you thinking about? I mean, that stuff, it's a 5-minute conversation, and driving all the way to Nashville and back just seems asinine to me.
Well, to confer, I just looked it up, means to discuss with the intent to make a decision. And we're not going to make a decision, so we're not conferring. Now, I know I'm splitting hairs, but that's what you guys do as attorneys, so split some more hairs with me. I mean, really, if we're going to, and it's silly to think that we're not going to have a discussion about industry issues. We got to walk around like this all day long. Tell me what confer, I mean, are you saying confer means to speak? Or did you choose the wrong word? Feel free. I'm not trying to put you, I know it sounds like it. I'm not trying to put, I'm trying to
Yeah,
protect
me either.
all of
Yeah,
us.
Me either.
I'm not trying to put you, I just, so don't feel like you got to choose your words real careful. We'll ask for more, okay? So just feel free. You're amongst friends. You really are. You're our attorney.
That is true.
Right.
To be honest, this is what I have been told by my direct supervisor, that y'all are not allowed to, like, two board members are not allowed to meet without it being noticed to the public that there's going to be a public meeting, and it would have to be recorded and have to be available for the public to be able to listen in. And I understand that you want to be able to talk about little things related to things with Frank, but again, that the department's position is that would be a violation of the Public Meeting Act unless it was appropriately noticed and the public had an opportunity to come listen to the meeting. I can look more into the issue, but that's what I have been told is the department's position.
Have having worked for government a long time, I've been involved in this a lot. And even on the pension board that I serve on in Knoxville, it's exactly what she's saying. We're not supposed to discuss any item that's going to come before us to vote on. And that's her the state's attorney's interpretation is consistent with what I've been told.
And I understand that, because I think at some point that's what the fear is that it turns into a deliberation on an action. But when you're crafting verbiage for something, I don't know how that can get there. And that's not the way the presentation was given to us, is it's for this specific, about deliberating for specifically about a vote, and I don't remember the whole thing. I would just ask that they reconsider some of this. And it's strange that that's a violation, but yet there are over, I think it's 800 and something exceptions to the Open Records Act in the state of Tennessee, where people can withhold information and do all this kind of stuff, but yet we can't meet for small conversations about things. I just think that's a little, that's not the intent of that record.
Steve, how do y'all get around it if not get around it in a bad way, but, if two of you are walking down the hallway and a topic comes up and, Brother A says to Brother B, oh, so what did you think about so-and-so? Because I'm trying to figure out, did y'all say, don't bring it up?
Yeah, we just don't talk about it.
Don't talk about it at all?
If we know something is coming to a vote, we don't talk about it.
You can still talk about topics not as board members, but as engineer consultant to consultant. Or whatever.
I am never going to speak to you again, Ricky. And you're glad, aren't you?
I'd never say that. Okay, one other thought to throw out there then, just that if I were charged with what, with the task, and I'm certainly willing to help in some way, but if I were charged with it, I would be looking at these and modeling a first draft either on one of the other states or on NCEES. I would not be talking to the architects, because I think they're going to be crafting their definition from one of the states or something from NCARB, and it may be totally different.
I think it's going to be, I will say this, just when he and I briefly discussed it at the last meeting, that theirs is not going to match ours.
I don't think so either. Now, when you set them side by side, there may be some key part of this that has to match that, but that can be done after they're crafted. But I don't think we're going to take this and then try to match the structure and all the terminology that's in the architecture. I think we're going to be producing something like this.
I agree. Here's kind of what we thought might be something that could parallel, and that would be the sub-paragraph, for instance, A, definition, B, exclusions, C, something else. But basically so that if you're a practitioner and you go to read the law and you say, where am I? Then you see the engineers parallel the structure of the definition to what the architects say. That's really about as far as we got on it. But I don't think there's any assumption that the definition of practice of the two is so different. And I don't think there was any assumption that we were actually going to be able to have a paragraph entitled, definition of architects and engineers, or even that they would use a lot of the same words.
I wonder if the way it is going to work is that we come up with this first effort, and then a meeting to compare the architectural happens like at the end of this meeting or before the big board meeting. As the meeting, as the months go on, that we accomplish that.
The thing that'll have to really be discussed is incidental. That's the biggie. So if we have the definition of engineering and we all agree that there's, quote, incidental architectural, and on their side they feel like here's the definition of architecture with incidental in it, then we have to make sure that we're not contradicting each other.
Yeah, I agree.
I've seen that in some of the preliminary information that they'd proposed back maybe several months ago, and it did have that language in there, which is a great cause of concern for me, because how do you define what incidental practice of engineering related to architecture is?
Well, I think, based on what I heard from other states over the past couple of NCWES meetings, because I asked people when we go, and that's one of the great reasons to be there, because a lot of these people, as you see, most of them have it, is that they could never agree on the exact definition for some things, and they couldn't agree even sometimes on what the exclusions were. And so they simply got to a point where they said, we will have to let cases come before us, and then we will establish precedent, and then we will all know that that's clearly, in that case, that is not incidental. That is the practice of engineering. And in that case over there, yeah, that's no big deal. Let that go. Because you can't define everything.
So,
and
unless you leave that element out, that clause out altogether.
And I'm not saying that I have no idea. This is the first time I've really looked at it in depth. But that was one of the discussions that we've had repeatedly since I've been on the board, is how much definition are we willing to put down, because we don't want to have our hands tied with regard to a case that comes before us. But at the same time, I'm a proponent of giving at least some guidance. You might remember, no, you weren't here, but I'm a fan of frequently asked questions in case you didn't hear. So general guidance, generally speaking, I think that was my nickname. Generally speaking, yes. Or generally speaking, no. So I think I'm in favor of that, but I don't think that we'll be able to tighten it down so tight that there won't still be questions. There's going to be cases that come before us, but hopefully we will have something as a starting point.
Looked like a lot of the states did not have anything in there about incidental engineering
Is that right?
or incidental architecture. I didn't see that in all of the states, so I don't know if there's something to be learned from that.
Frank's the one who brought that to my attention.
Yeah, something that we need to discuss there.
Yeah.
So,
Yeah. That might be a place where we differ. The architects may want something on their side,
oh no, I was
and we may say differently.
at the NCES annual meeting. No, it was at the Southern Zone meeting. I was asking about this, asking around to the different state constituents, and I was pointed to Oklahoma's by a couple of people, like they would always say their states, and then they might say Oklahoma.
Right.
So I thought, Oklahoma sounds like that's pretty
Good one.
a good one as far as what other people think. And I talked, is it Bob Zale? Is that the guy's name? And he mentioned that they had gone through, that theirs wasn't that old. They wrote it, and they had some problems with it, and they fixed it. It's much better. And I can't remember what the specifics of that. But anyway, that might be one to look at if you're looking at which ones to start with. And just a lot of them look very similar to me, and a lot of them made me think how wise we've been not to have a definition. But we won't go into that. That's backing up. They're all going to not make us happy. But I think because it doesn't define an engineering. But I think that we've got to look at the track record of what the other states are doing with it, and what we're getting out of it, how it's going to help us.
Well, one of the issues in the NCWS model law is on the front page of Ashley's very well done memo, thank you, front page talks about surveying incidental to the practice of engineering. Now, I don't think we want to get into any kind of something that is crossed over with surveying, right? Oh, we do?
I do.
Yeah, they want to.
Yeah,
Have to.
Yes, I agree.
Okay.
Because I'm not saying it as a defense mechanism.
We want to write something that's opposite of what they wrote?
Well, what they're proposing to write in their, maybe they've already written as part of theirs, gives them the right to practice engineering.
I don't know, it's not, yeah.
But most of the states have something in there about incidental surveying, or the surveying, the kind of surveying that engineers can do in there. That is.
I just meant we didn't want to put something in there that was the opposite of what the surveyors were saying,
We may have it, though.
Gotcha.
but we might.
We might have
Okay.
it.
I got you.
Interesting.
I mean, I think when you look at some of the surveying data, I'm trying to use the right words, surveyors need to be limited to data that's collected that uses their methodology for reduction of error, not just for simple measurements. And that's a difference. They use techniques to reduce the error of the data sets, whereas engineering surveying is just basic measurement techniques. Is it 5 feet long? Is it 6 feet long? Is it 14 feet away from here? Is it 6 feet high? It doesn't use some sort of derivative error. And they may come into other areas too, Kathy. And that's always the fear of having a definition is, or not having one, is that people creep into where you are and you end up having fights about it all the time. So.
Oh, it was going to be that much fun. Hey, if you look on page 6 of 37, I'm not sure what number, but Arkansas actually defines number 3, a person who is a licensed engineer in another jurisdiction shall not be considered to be offering to practice engineering, blah, blah, following, and then turn to the next page, if he responds to an RFP. So Arkansas actually has some stuff in there relative to defining engineering as to the whole
Where is that, Kathy?
page 5, and starts on page 5, the bottom of page 5, number 3 of the memo. I'm sorry, I'm not sure what it is in the tab, but it's in Ashley's memo. It's the 5th page, 5 of 37.
Page 6.
Is it page 6
Page
of the
6 on
tab?
our thing, yeah.
Page 6 of the tab. Arkansas regulations, practice of engineering, item 3. A person who is a licensed engineer in another jurisdiction shall not be considered to be offering to practice engineering when soliciting work by any of the following means. And item
Yeah, that's interesting.
B is response to RFPs.
Yeah, as long as they disclose that they're not licensed. That's and in my informal, and I need to study. These are good. Study everything Ashley's gathered, but it seems like more states don't want you to respond to an RFP than will allow you to.
This one allows you to.
Right, and that one allows you to.
That's right.
That's just for RFPs, not
I know.
RFQs.
Yeah.
RFP's got a price component to it. Letters of inquiry, we allow that. I mean, if somebody says, hey, can you do it, we allow that. Regarding requests for proposals. Again, it gets, that whole thing is a request for proposals got a price component to it. A request for qualification is price after qualification.
That's where, see, they're accepting. We agree with those first 3, A, B, and C, but they add that you can submit a proposal, which is different from
proposals.
us. Yeah, which is different from us.
But it's proposals based on submitting references for qualification, not a proposal. Telling you the difference between a proposal and a qualification, an RFP and an RFQ is broader than you think.
Right, but they're using the word proposals, though. I'm a little confused.
Too, because the reason that we don't allow it is exactly what happens in the last sentence that they put in there. There is a risk that somebody that does get awarded based on qualification is not able to get right, and then all of a sudden you have to go back through that and you've harmed that. So I think we're on solid ground by not doing it, by making request for qualification. But now, if somebody calls me and says, a private developer from Arkansas and says, hey, I want you all to come and design a water park in wherever, I think that's legitimate. I mean, they're asking me for a price to do that, and it's not a government entity. It's a request for proposal. It's not a request for qualification.
My understanding is that if I'm not licensed in another state, I can't give somebody a price proposal. I cannot. Correct? You don't agree with that?
Depends on who's asking you for that.
No, I'm talking about a private entity. I thought it was in our rules that we consider offering a proposal, a price proposal, or an RFQ as practicing engineering, and that we can't do that until we're licensed. I mean, when I call I do work with in a bunch of states, or I'm asked to, and I call their boards and ask, can I do a proposal if I'm not yet licensed in your state? And the answer is 9 out of 10 times no, because of, and I think I've received the same answer in Tennessee when I have asked on this topic, that you can't private. This doesn't have anything to do with public. It has to do with licensing and states consider practicing engineering.
Well, let's not, I mean,
Yeah.
we're talking about definitions too.
We
I
are,
think
we
we've
are.
talked about the other, and we've got a position on the other, so.
I got
Okay.
a question for Ashley, since we're on it then.
Okay.
So Ashley, if you would do us the favor then, boy, aren't you glad you took this job? Are you the attorney for the surveyor board?
I am.
Okay. So who's going to be the arbiter of which board verbiage is approved? How somewhere along the line, those two, if they're in conflict, will be resolved by somebody. Who is that? If let's just say, as an example, this is a crazy example, the surveyors say, by definition, if you're a licensed surveyor, you can also practice engineering. And the engineering board comes up with language that says, by definition, if you are an engineer, you can perform professional surveying. And it goes to the top, and there's also exclusions on both sides. Where is that going? Who's going to decide those things?
So I will first say that land surveying is statutorily defined already in the land surveying statute. Sorry, I was sitting here trying to pull it up on my.
It is basically the NCAA definition of.
Model law
Yeah,
for.
yeah,
Okay.
pretty much.
Okay.
So if our definition is pretty much, or at least relating to surveying, the NCAA model law, we're going to be, yeah, unless a change is proposed that changes that dynamic.
Right. So if there's conflict, does this happen? Are you familiar with?
I'm not that we've had this close knit where they're not a merged one profession where you would have to do it. But I think at that point, legal would look at the definitions and they'd have to, not clash with each other, not create a problem, and kind of bring us back to the drawing board until we got to a place where they didn't contradict each other. But
Robert, what are you aware of that surveying they're trying to change some of their definitions right now, or are you just referring to their existing definition?
I'm referring to this, so there's been two debates that primarily hit on the borders. One is when you do subdivisions and you lay out roads and alignments that they've been allowed to do, and then they move over into drainage. Okay, and that, by the Attorney General, we've said no, but then there is still a fine line. Where does the vertical component of something start with respect to surveying? Then there's also been the incidental surveying. So if I go out and measure this building, is that surveying? I don't know. I mean,
what purpose of the survey is.
well, I mean, yeah, we allow for as-built surveys and stuff, but if an architect comes out to measure this building, is that surveying? I would say no. I would say it's a measurement, because it goes along with, I think, the definition for surveying. Steve, you may have it more than I do, talks about the art, the science of taking data and attributing error or minimizing error or something like that.
I think the difference, Robert, is if you just take a tape measure and measure the dimensions of this building is one thing, but if you're out here with an instrument and you tie it to an iron pin, that may be something
Because
else.
I can take an instrument and do an as-built survey as an engineer of an as-built condition, just to measure stuff in from a reference point, and that's allowed. So it's not what instrumentation you're using, it's actually, but that's going to be one of the problems we're going to run into. I mean, that's something that came up in NCAAS like 3 years ago, and I think it was like Vermont or Maine or somebody that went ballistic, they're surveying people about that incidental measurement thing, because you and I, let's say we go out and we're going to measure driveways for a water line project. Well, that's not right. You and I can do that, can't we? We can, but some people would consider that surveying because it's going to be put on a map that's going to be used. Some would consider that not. And there is a definition to that, but I'm saying that's an argument on the edges that we can get into if we're not real careful.
I assume there's similarly arguments the other way for things that the surveyors want to do that they consider surveying that are actually, we think, practices of engineering.
Yeah, but I mean, there is arguments, and you don't get into it as much in the larger metropolitan places because you've got enough surveyors and you have enough engineers. You run into that situation where you're in other areas where they don't have the depth of talent that you have here, and your local surveyor is your local engineer, and they do geotechnical work, and they do all kinds of stuff, and I think the Surveyors Board's done a good job of trying to minimize that, but that's still an issue we're going to go back and forth with. And now we're entering drones and LiDAR and all this massive data collection stuff. Well, I can fly a drone and get data from it and take photographs and do stuff and tie it to reference points. You're seeing real estate people that do the same thing, that will fly over your house and take a picture, with using a GIS map and saying, oh, here's your boundary survey for your property you're getting ready to buy. Well, if you take that, you're a fool, but people do, and they go, well, here's my boundary survey. So, I mean, there's all kinds of, and I'm just using those as examples of what practically speaking, it may not be a huge deal right now, but we need to make sure that we've set up some sort of firewall for it later on, because that's how we got in the drainage argument 20 years ago that the AG had to weigh in on and say, if you're doing drainage, that's engineering, because engineers have been classically trained to understand hydraulic equations, et cetera, et cetera, et cetera. So anyway.
I like Rob's old definition: engineers design, surveyors measure.
This is how I got involved in TSPE and NSPE in the early 80s, but the surveyors used that term layout of vertical and horizontal alignment to mean design. Engineers say that's staking it out.
They're different things, right?
Wrangle back into the definition of engineering.
Definition of engineering.
Well, before we go any further, I do want you to know, take heart in the fact that we might be in the same category with California, but we are also in that same category with Hawaii. So, aloha. They do not have
We need a committee meeting there.
I think we need an on-site investigative committee.
Roxana, will
Y'all
you
could
ask
just
the
send me.
administration
I will
about
do
that?
that.
Just send me, and I'll report back to y'all.
I don't trust you going by yourself,
No.
Kathy. Yeah, sorry. You need an escort.
You have something else on
Other than
definition?
just we've debated a lot, and I think we're starting to deviate a little bit. I want
Okay.
to come back to the.
So do we want to, as far as definition, do you want to set any kind of goals for between now?
No, because then you'll hold me accountable. I would ask, Ashley, can you send me, so I don't have to go look it up, the surveyor's definition, please? Just that section. When I casually bump into Frank tomorrow and we don't talk about this, we'll have a recommendation on what we should do. Is that okay? But I feel like I need that. Based on feedback from Roxana and Ashley, we need to figure out.
Yeah, and I'll provide that to you, but I just also want to specifically mention that the definition of the practice of land surveying is found at Tennessee Code Annotated 6218-102. Yes, specifically item number 3.
Statute's not on your, sorry.
Okay, moving on, the next letter I see here has to do about questions about practice and ceiling requirements. And it looks like something maybe that Alton handled, and we put in here maybe so that we can discuss it. Alton, can you want to lead us through that?
On page
What was
39 on your tablet, and it's 39 and 40, and you'll see in two different colors of ink, kind of. I think we had, Ricky, you might have also responded. I think two of you responded to it, and so I know before we forward the official response, we wanted to make sure that we agreed.
Look in your library.
Yep.
Look in B.
$39 and $40.
The one I remember, Roxana, that I looked at was, maybe it was similar, but it was a different one, correct? I looked at a question recently about, do you have to be a registered PE to do? It was from somebody who was in the industrial world, and most of what they were doing met the industrial exemption, except they were started to do something to their building that would need to be permitted.
We need to send that out for the full board to review as well? I can see if that went out. Okay.
That was one that I sent to him the other day.
Oh, okay. Didn't ring
It
the
wasn't this one.
bell. Okay.
Wasn't this one, so I don't remember.
You answered this one early, about a month or so ago.
I did.
We've got 5 questions. If we can just sort of review their understanding. That's what I'm trying to remember. That's a great question. I thought Ricky was, but Alton, I think that you had the blue statement. Yours was the second follow-up. I thought, Ricky, you were the red.
Okay, let me read that.
Yep.
Okay, I can explain the first question, or what my thought was there. I do remember that. There was, first question says, does a registered professional engineer need to seal any document that they produce, a drawing, spec, sketch? And anything prepared under a registered PE must be sealed per the requirements.
But there are exemptions to that.
And my answer was, I don't think that if a registered PE did a structure that was not required, that didn't require a PE to do it, that the PE didn't have to stamp it. But I told him, since I hadn't heard that question discussed before, I would probably stamp it anyway. But so if it takes a So if a 3,000, something less than 3,000 square foot structure really, it, by law is exempted, doesn't need to be stamped. That, the question was.
Under 3 stories or less than 5,000.
That's what it is, yeah, yeah. So, so the answer was, I don't think so.
As a PE that does a lot of environmental work, it's not design, but we do environmental work that is not considered engineering. It's assessment work or investigation work or a sampling plan. Engineers that are otherwise registered sign documents all the time and they do not apply their seal because the seal is not required by law, and it's not a design issue, it's something else. So I think the issue should be governed by the actual requirement, not whether or not the person has a license. This guy's saying, if you have a license and you issue a document, don't you have to sign and seal that document?
Right.
And I think clearly, no.
It's only, we would only require it when the laws and rules require
Document
that
to be
what's
signed.
being done has to be
The
done
work
by
product.
PE. Otherwise, he's okay not,
I
he or she.
agree with that.
Is
My only issue was that if this individual was awarded the project or the job, whatever it was, specifically because he was a licensed professional, then if I'm not going to see that, I think he owes the obligation to whoever's hiring him. Hey, look, this doesn't require a seal.
Yeah, but that's a contractual issue. That's
Well,
not-
but I think it's also an ethical obligation. If he's hired because he's a licensed professional, and that excludes other people from being eligible to participate in this work, then I think ethically he's duty-bound to inform them, hey, look, this really doesn't require a seal. You can hire somebody that is able to perform these services outside of somebody who's a licensed professional.
Okay, we all,
Well, wait a minute. What does it say
I
here?
think you ought to stamp it.
and I don't.
Because he can?
I don't see anything.
Why? Why?
Evidently, he thinks it's engineering work, or he wouldn't have been doing it. So I think there's some added value to the client for engineers to do design that's not, maybe not required by the law, but why not? I mean, what's the problem with stamping it?
I don't think there's a problem stamping it. In other words, I think,
Now, whether or not we can require it, I don't know, but I think you ought to stamp
right,
it.
I think that's a different question.
It is, but
Is it-
Lawyers
that's-
will have to tell us that. I don't know.
It's a different question, but if there's a building that clearly meets the exemption where it does
Okay.
not require a registered professional, like a,
So if the building doesn't meet falls below the
Below the threshold.
the threshold, and there's a foundation issue like we've reviewed many times, does that have to be stamped?
does not have to be stamped. I mean, if it's a 2,000 square foot, 1-story metal building on a farm, it doesn't have to be stamped by, a PE doesn't have to design that. That's per our law.
Doesn't have to. So then can a non-PE geotechnical technician go out and write a report and say the foundation's okay?
I think if that structure doesn't, if that structure meets the exemption, I think so.
I think the exemption's in there for a specific reason, and again, anything less than 3 stories or 5,000 square feet doesn't require a seal. Whether we agree with it or not, that's what the regulation says, I believe.
I think the point of the regulation is to allow others to do that work. I don't think the regulation really deals with whether a non-professional would have to stamp it.
I don't,
Because that's,
I agree with you. I just don't see anything that says if you're a design professional, now you need to stamp that. I don't see that.
I think we've told people that before, but I
Okay.
can't remember the specifics. You remember anything like that, Robert?
Well, that's what I'm reading. So we understand the exemption. Got it. Okay.
Yeah.
And but when I read this, and this is the seals thing, it's under number 2 here. It says the registrant shall.
Where are you, Robert?
62. I'm holding.
Not 62.
It's 0120. It's the seals rule. 0120-02-08.
It's under professional conduct.
The problem is there's no exemption to the seals rule. I mean, that's the issue here, not that, there's nothing that says you don't have to use your seal if it's, and let me read the things that I see. Number 2, which is often on page 7, or the page at the bottom says 7, is the registrant shall stamp with the registrant seal the following documents. All original sheets of any bound or unbound set of working drawings or plans. Original sheets shall include tracings or other reproducible sheets. The original cover index sheet identifying all specification pages covered, and the original cover index sheet for design calculations that are submitted for the review. There's nothing in that section that says unless it's exempt from having an I think anytime an engineer touches a document, their threshold is, did I do engineering on it stamped? I mean, that when I read the seals law, you see,
That's where that comes from. That's what I think too.
because I was looking down through here and I didn't get all the way in here, but I was.
Look at that.
Advise that any engineering report be stamped, even if it's one page. A lot of those deal with these houses that fall under the exemption.
We do now. That's what I was going to tell Robert. When what he just read you is under the rules, under the laws, the
That's what
the article about seals
62
under laws too. Yeah, let me get that. That's so under our law about seal. It says, the registrant shall stamp with the registrant's seal all original sheets of any bound set of plans and the first sheet of any spec or reports. It adds the word report, so we were taught laws are supersede, they're stronger than rules. So that's what tells me reports have to be stamped.
I think it does, and then
So I don't, and I'm like you, I don't see anything that says exempted, except exempted structures or whatever.
My world, there's that section about, I think we've changed the legislature changed the limit. It used to be $25,000 per year, but it's talking about the design or maintenance of a public work. We would design a lot of things that were under that amount, but they all got stamped because an engineer did it.
Right.
Now, if another department, let's say in the city, decided they wanted to renovate a bathroom in a fire hall or something that was below that dollar amount, and a professional we weren't involved, then obviously we didn't stamp it. But,
Right.
I think that what Robert referred to is where that we probably advised someone in the past that if the registrant does the work, you stamp it.
So what both of you are saying is there are things, mainly structures, that can be exempted from a design professional from doing it, but if a design professional does a structure, even exempted it, they need to stamp their work.
I think it says that in
Yeah, I mean, it's very similar to what the rule says.
I
just
think the
has-
exemption is not to save some ink on the stamp, it's to let others do that design work.
Hey, here's a question then. We're talking about this up here and kind of coming to a consensus. I guess we can vote, but is this a legal question that needs to?
So that's a great question. No, this is an individual that has sent us an official in writing, need help with these 5 questions for us to respond, and they were in depth enough that they required your experience as licensees more so than just legal.
Okay.
So we can craft them, or if you like and you've got a good indication, I can send it back without all the red back, and we can answer, Friday or early next week and send them. So we did let this individual know that the full board was going to kind of make sure that we answered correctly.
Well, I think we don't need to contradict whatever our legal advice might be, but I guess as board members, we're just telling both of you what our opinion is at this point.
I think in accordance with 622306, part clearly states, if you're a registered professional and you're performing that service, then you have.
Okay, so with that interpretation, the answer to his first question would be,
Yes.
if a PE does it, it needs to be stamped. Okay. Kathy, any statement?
Well, yeah, I'm trying to make sure, make sure. I think most environmental firms who employ PEs and lots of other non-PE professionals are not sealing documents, even though they're signed by a PE.
And I agree.
Because they're not plans and specs, but I'm reading in B, right where y'all were talking, it says plans, specs, and reports.
Yeah, and I think that the reports not being stamped when a PE does them is a really common thing.
I assure you, it
but-
is SOP.
But
We actually stamp all the reports.
But I think the law requires them to be stamped, and it just says a report. And like you said, a one-page report is a report. So I can't make any argument that you can't stamp, that you shouldn't stamp a report.
So though, would you say, when I say environmental, I'm not talking water, wastewater design. I'm talking hazardous materials in the soil, in the groundwater, in the air. So those things are done by environmental scientists and others that are non-PEs. Should a company have as a policy that PEs do not sign that stuff unless they seal it? Are they going to be held in violation of the registration law if they don't seal? Go ahead.
So the question, and a good question, but the question is, are the acts that the reports they're preparing, is a PE required to prepare that report?
No.
Okay, well then, they're not in violation, but now if you.
That's not what you just said about the 3,000 square foot building.
Her question was if a
That's
PE
different.
does it.
Yeah, but if let's say I've got a soil scientist that goes out and does a report and says this land will perk or something, okay?
Right.
They're not a PE.
Right.
So they don't have to stamp jack squat.
Right.
Okay? But if you went out and did that same test and said this land will perk, you better sign and stamp it because you're a PE. Now that may be exempt. It may be an exempt because it's under the acreage or whatever. You touch has to be stamped.
Or anything that was prepared under your supervision or in your responsible charge.
So I'd like to go ahead and report myself.
Well, again, I think this.
I think it's very common.
I think
No, I'm telling you
I-
it is.
I- we know
I
it is.
assure you.
Yeah, and we would need some. I mean, this. If we
That-
ever do a
what-
newsletter again, that would need to be in.
No
the,
kidding.
An article about reports.
That's the whole
need to
point
be
of those kinds of
stamped.
newsletters, is to tell people when interpretations have changed or that y'all need to be aware, right?
I think it's always been this way for a lot. Like for instance, we stamp pay requests because if I'm preparing it, I'm a PE.
Yeah.
I stamp it and sign it and all that stuff. And then he go, well, it's a pay request. But if my inspector does it, who's out on the job, and he signs then I don't.
You don't worry that he's not you.
Right. I mean, because I didn't touch that pay request.
Right.
And there are a lot of pay requests that come through there that I don't see because they're done by a technician or whatever. It's only I get involved if there's something screwed up, I'm sure. But
So are you saying in that circumstance, it wasn't prepared under your responsible charge?
right. I mean, it's just it's a normal keeping up with sticks of pipe kind of thing, and it may not require me, but the ones that I touch, the ones that I review, and there's some that I have to because of where they are and what they're doing. Yeah, I sign them and stamp them and do all that stuff.
I think you're really opening a can of worms on this. I mean, everybody from the biggest engineering firms in the country, pick a firm, AECOM, Jacobs, et cetera, down to local firms like myself with less than 50 employees and been around for 20 years, mainly in Middle Tennessee, are operating under the assumption that if it's not required to be sealed, just because the person who's signing it is a registrant doesn't mean he has to apply his seal. And, this, I think we need to think long and hard about before we go on the record as saying that this is how it's going to be interpreted down the road, because, I mean, we could have literally hundreds, if not thousands, of claims against registrants and, for exactly this issue. That's how common it is.
I understand the severity of it, but I also understand what the words say in our Tennessee Code annotated, and I don't think it gives us any flexibility. I don't think it's ever
Did you
given us
find that,
flexibility.
have you read this?
I read it. I disagree.
Pretty straightforward.
I don't think it's necessarily that straightforward. I think it's
The registrant shall stamp with the registrant seal all original sheets of any bound sets of plans and the first sheet of any specifications or reports prepared by the registrant or under the registrant's responsible charge.
But I think without definitions of what constitutes a bound set of plans and that kind of stuff, without definition of what constitutes a required document to be signed and sealed to start with, I don't necessarily think it's that cut and dried. If you have a 3,000, we keep going back to the 3,000 square foot building. If you have a building that is exempt and anybody can go out there and design it and put it through codes, and the guys say, well, where's the engineer? Don't have to have one. Read right here. Don't have to have one. Then how are you going to fault a guy who actually is an engineer for a set that didn't require? I mean, that's like saying, well, we're going to penalize you if you have a master's.
Because we hold ourselves to a higher standard.
We are engineers.
Well, I
that's why we
understand
do
that.
Yeah, and we have that obligation to perform at a higher standard.
Yeah, I don't know.
I guess, Kathy, one answer could be it is in the best interest of the public safety, health, safety, and welfare if an engineer does something for consumption and their stamp is on it. It helps the public to see that a PE did that, as opposed to got a 2-story, 4,000 square foot building that a non-registrant could do, but you as a PE did, and your stamp is there. It helps somebody know that was done by a PE.
I think you're creating a competition issue too. I mean, you're actually taking engineers because they have a registration and putting them at a disadvantage. Don't have a registration because they'll be able to do things that engineers might want to do for cheaper, simply because now you're going to make that guy sign and seal all his stuff.
How does that add cost, though? If you're going through the process of doing the analysis and everything anyway, how does that? If I'm designing, let's go back to our 3,000 square foot
Because
building.
if you're telling him that by putting his seal on it, he's held to a higher standard, then he has to spend more time on it than the guy that doesn't have to seal it. Because the guy that doesn't have to seal it can just say,
Actually, it may be the
I don't
contrary to
understand.
that. Because he has experience and knowledge and education, it may take him less time to do it than somebody who doesn't know or understand the codes or requirements or design elements.
What you just said is.
Then
an
you've
engineer
created a
doesn't have-
disadvantage to the other guy.
But you just said that an engineer is not going to spend as much time if he doesn't know that if his stamp's not required. And I would say
not what I
that's a
said.
false, well, but that was the corollary. I would say that's a false argument because the engineer's going to spend the amount of time it takes to make sure that it's correct. The other person may not, and that's obviously a risk that an owner would take. But, I mean, I'm going to take the same amount of time whether I am, because I'm an engineer and I'm held to that standard to do it. And if somebody wants to say, well, I don't have to pay for an engine, I just don't see how the cost thing, I'm going to take the same amount of time whether I'm required to stamp it or not required to stamp it because I'm held to a standard to protect the health, safety, and welfare of the public. No stamp. And I just think it's pretty clear, and I understand why people have not been doing it, but I don't think that's correct.
I think if one of these smaller buildings, if there was a failure, and it was determined through litigation that an engineer designed it, whether he stamped it or not, he's still subject to the same liability.
I think it's, I mean, the justification is what it means to the public and the contractor building it and all of that the stamp is there.
In relation to this specific question, questions 1 and question 2, the answer is in accordance with section 62 or statute, TCA, 622306 Part B, yes.
I agree on number 1. On number 2, I think the question there is if the building was exempted, didn't have to be sealed, if then you had other disciplines like mechanical and electrical plans for that building, would that have to be sealed? Then based on our conversation, I would say if it's an exempted building and a non-registrant did it, there would be no stamp on it, it'd be okay. But if a registered engineer did it, they would need to stamp the drawings based on our
I agree.
conversation.
That sounds right to me. Carrier guy to size an air conditioner unit and he's not an engineer, then he go out
Right.
and size it, then I think you have to.
I agree with that. Number 3, I
Probably
think.
going to need, and I understand where Kathy's coming from because it's not something that's consistent within the industry. I mean, it's just not. It's sometimes reports are seen as almost internal as well or part of something else. Probably need to make sure that we're on solid legal for that we're not looking at the words incorrectly or we're not taking. Seems cut and dry to me, but if you don't mind, we probably do need to make that determination. Just make sure we're not parsing out something that creates a bad deal.
Well, and I mean, I just totally disagree. So I look forward to hearing what the recommendation is from legal with regard to what's required and not required. And if it turns out that there is such a thing as if you're registered, every time you sign your name to something, you better put your seal on it, then the state has an obligation to tell people. And you can't just sit here and wait for somebody to get thrown under the bus. That's just ridiculous because standard practice is if it's not required to be sealed, you don't seal it. You just don't. And to suddenly have just a ruling, that's bad business.
That wasn't one of the FAQs, was it?
Oh, sure. Well, generally speaking, I think.
But that's not. But I mean, it's not something we've dropped on somebody. This has been in existence for a long time. I think it's something we may have gotten sloppy on in the practice of, but I don't think it's been dropped on somebody. I would disagree with that.
We'll say, I think that somewhere in the last couple of years when we were updating the rules, the seal section of the rules, that I suggested adding reports to the rule right where the stamp rule is so that it matches the law, just so it would be more, I thought it'd be helpful to people. I don't know, I see it wasn't there in what was printed for us last time. I don't know if that is somewhere in process, or that did that never get done? Did I never do that? But that's adding the. I don't know if we've got some rules that are in process on that professional ethics chapter.
I don't think the ones that Liz moved forward included anything.
I don't think they did either. I think they were something else. But
I know a couple of topics have come up for the next time we need to open rules and work on. So maybe that would.
yeah, this was a couple
One
of
of
years
those.
ago.
Okay.
I need to look for that and see where that landed.
Let me know, or once you've got an idea of a time frame, because I don't think anything like that's in the pipeline.
Okay. I will let you know. Okay, so we're not taking a vote on that last discussion, but we've got to answer this person. It sounded like vote, but it sounded like the majority people said the answer is yes.
You're okay, yes, I may. So he's got 4 and 5, but if you think that we're at a good place, he's got question 2, 3, 4, and 5. They seem to not be that different. I can send it back out.
3
to you
was.
to
It looked
respond.
like 3 was a different question.
Yeah, three's
It was about it was the industrial exemption question.
Question was, does a large company have jurisdiction at their site to determine the ceiling requirements for project? I thought that if they were building a building on their site, they're not exempted.
It says, that opening paragraph, the following shall be exempted from the provisions of this chapter, provided, I'm going to skip some, nothing in this section shall be construed as exempting any person who makes public use of the title engineer, architect, or landscape architect, or any appellation employed by the state of Tennessee or its political subdivisions. But that's public use. But these, like, for example, if you're working for Eastman, like in his example, not a public entity, it's a private entity.
See, I don't see that as you've got a place. If you've got a building that's a 10-story building,
the public could go in.
They can go in. If salesmen can go sell to the people, they can have meetings. You've got, family can go to work for them. That building needs to be designed by design professionals, architects and
I
engineers.
wholly agree.
And I don't think that statement says that it can't be. I think that building would have to be designed by design professionals.
That's my last comment. I know what paragraph 3 says, but that it exempts them, but I said I'm not aware if there are any other requirements based on the type of occupancy or assembly where this rule would be overruled if those services were provided to their employer or employer's industrial site, like if they built a training facility or an office complex, even on their own plant site, where they're going to have some type of occupancy.
I think the buildings that they would go on their site would be have the same rules as the exemptions. 5,000 square foot, 3-story. I think if a building that Eastman Chemical built on their site didn't meet the exemptions, I think it would have
process that they had going forward that need to do that. But I think there's two parts to this question as well. I think we go back to question 1, which I know Kathy disagrees with, but I think anything that the engineer touch, if he's a professional engineer, even if you're under industrial, it should be signed or stamped or sealed. Okay.
Right.
But the second part of this is what's the process for sealing requirements, because we have the process, for instance, when we submit to a building official, we need to stamp it. Well, they have no building official so when do they stamp it? What's the revision process that they have for when that stamp becomes So they can have internal processes that say you only stamp it at some level. You don't have to, I mean, I think that's certainly allowable within here, because our requirement is anytime we go from our domain to somewhere that could be in a public domain, like a building official's office, a client's place or something, we're supposed to stamp it. But I think if it's internal and they're doing some internal process and the engineer's doing it, I don't think he has to stamp it to the end of that process. But that can be addressed by the entity that's exempt. We don't have any jurisdiction
Well,
over that.
the end of that same paragraph, that same section 3 says, services to their employer only and not to the general public. So in the I guess the example that Ricky was given about what if it's a building that vendors or suppliers or other people from off-site come into, that's the general public. So if you're designing something that people outside of your own organization would use and enter and be in, I don't think the exemption applies.
Eastman Chemical, and you're doing a line to process whatever, in theory, that's an industrial exemption. But again, I think if you're an engineer, if you're a licensed engineer working on that process, you should stamp what you're doing. But if you're an unlicensed engineer working on that process, you don't have to stamp jack squat.
I agree with that statement.
I mean, that's kind of the dichotomy of the whole thing.
I think I see a difference in industrial exemption with when you have processes and you have employees that are designing processes with doing something like building a building where, employees are not building the building. I mean, they're gonna hire contractors to do that. They're involved. They've got codes they have to follow.
Well, the industrial exemption deals with the employees of that industry.
That's what I think.
That's what it says. So
I think the question is, what if one of their own engineers is designing a building that's going to have...
it says they don't have to be licensed.
Where does it say
But
that?
if they are licensed, then
Well, yeah.
Where does it say that?
In number 3.
Number 3.
Where, what, I mean, number
Oh, 62-103.
3.
Paragraph 3. Architects, engineers, or landscape
If you want to go to
architects
that, you got it. You got the
Yeah.
okay.
who are employed by a person, firm, or corporation not engaged in the practice of architecture, engineering, or landscape architecture, and who render architectural, engineering, or landscape architectural services to their employer only and not to the general public.
If Eastman decides to contract with a consultant to design a building,
They've
they
got
would
to
have
see
to stamp it because they're not employees of Eastman.
or if they have to take that building to a building code official to get something certified, then they've broken outside of their industrial exemption bubble, and now they're in the public domain again.
If an employee designed it,
Yeah, I mean, if Eastman has to go and they say, okay, we're putting this mezzanine in, and it's got to have, the public building official says, yeah, I've got to approve that, then that has to be stamped, or the public building official can't approve it.
that makes sense to me.
Interesting. Does Eastman have to submit buildings or other construction done on their site to public building officials?
A lot do. I mean, when they build a new plant somewhere, that gets submitted to codes people and everything to look, do you have enough? I mean, Walmart's with an industrial exempt thing, but how many Walmart sets of plans have you reviewed? I mean, it just.
Oh, sorry, I left my phone upstairs.
I agree with that, Robert. I mean, we've done a lot of design work for private industry that had to be, if it met the criteria, it had to go through code review process.
Kathy's going to tell us some stuff that's going to keep her out of prison, so go ahead.
Okay.
Print this off, and I'm going to carry it with me at all times. No, so I went to rules, and I know laws trump rules, but rules say, page 7 of your rules, if you want to look at it.
What chapter? of the rules?
This is, hang on. In your library, this is 2 AE rules. In your library of documents, AE rules, number 2. And in the document, there's 47 pages. This is page number 24 of 47.
Okay.
At the bottom, it says number 7. The registrant shall stamp with the registrant's seal the following documents. All original sheets of any bound or unbound set of working drawings or plans. Original sheets shall include tracings or other reproducibles. Original cover or index page identifying all specification pages covered, and C, the original cover or index page for design calculations that are submitted for review. Blah, blah, blah. The rest of it is the details of what the seal
In
supposed
the
to look like.
rules, which section, Kathy, were you in?
Page 24, right?
Are you in number 2?
Yeah, I think so.
Okay.
2A, it says 2_AE rules, right, at the top. I mean, that's the
Yes,
document.
that's correct. Page
And-
24 of 47.
Right, and I missed one because okay, so it says we're on number 2, right?
Right. Number 2, the registrant shall stamp with the registrant's seal the following documents. It doesn't say anything about reports.
That's what I was saying. When I noticed that our law says the exact same thing except for it has the word report in it, and this doesn't, I think I marked that up and sent it in to add the word
Conflict.
report so that they're the same.
So that they're
Because
the same.
right now, the way it was explained to me when I became a member of the board, law trumps rules.
I understand.
But it sure would help our
If they were consistent.
registrants out if they saw the word reports there. If
But now that Sarah's here, she's going to set us all straight.
there you go. As always.
But I think that's something that needs to be added, or we need to clarify it on some level.
I don't disagree that it ought to be clarified. I just totally disagree with the interpretation that it's automatically assumes that every report that goes out, if you're an engineer, if it doesn't have to be sealed by an engineer, just because you are an engineer, I don't think that means you have to seal it. I just disagree with that. So, Sarah?
She doesn't know what you got into.
Well, if we're going to interpret it that way, then I definitely think laws and rules should match. But if you look at what it says here, it does not make reference to documents other than, the traditional plans and specs that we always think of as having to be signed and sealed. And if a building is exempt from having to be sealed, even the plans and specs for that building, and you happen to be in it, I find it a leap that just because you're registered, you have to sign and seal those. I think I just have a hard time making that leap.
I just think the industrial, the exemption does not, the exemption is where it says you don't have to have a registrant if you do this. But I still think the way the sales law is, it says if you are a registrant, you have to do this. Regardless.
But if you read the rule, it doesn't call out.
Well, I know the rule doesn't, but I think the law does, which.
Law specifically says reports. And I agree and understand with what you're saying. Technically, any letter that you're writing, giving some engineering opinion based on the information gathered and the experience that you have to any client would technically, I suppose, be a report.
I'm going to fix it in the definition of engineering. How's that? Keep trying, keep trying, keep trying.
Okay, so
back on
back to number 3 here. Can we say for the Eastman thing that if a building has to go through the code review process and be permitted, that a PE that Eastman doesn't decide, it's not up to Eastman the rules about stamping and sealing, that has to follow the rules that are in these laws and rules.
Because Eastman's not under our jurisdiction, the registrant's under our jurisdiction, whether they stamp a set of plans or don't stamp a set of plans. Registrant is under our jurisdiction. And these laws are written for the registrant. They're not written for Eastman or anybody else. They're written for our registrants. And our registrants have a set of rules, laws that they are supposed to follow. And now the rest of the world has whatever other stuff, exemptions from that rule, exemptions from that stuff. But if our registrant does something internally that they do engineering work on and have to stamp, they'd stamp it. Now, Eastman can have their own process that says you stamp it at this time rather than this time, or you whatever. I think it's pretty silent on all that, because we have to stamp it when we send it to a public official, codes official, or some other official, or it goes to the public domain, which in theory that will never get to the public domain. But that still doesn't relieve the registrant of having to stamp what they've done. Now, Eastman can say, oh, I've got an engineer that's going to work on this process, or I've got 3 technicians that are going to work on it. We're just going to let the 3 technicians work on it. The engineer doesn't have to work on it. I think Eastman can have their own processes for when it needs to be stamped and signed, but they can't dictate registrant stamp or sign it, because that's our job. That's not Eastman's job. Or else, why are they registered under the Board of Architects and Engineering Examiners? Why aren't they registered under?
It makes sense to me when there are building structures involved that need a permit, or like a roadway, or something that's on the private campus, because the public can use it. But for like a process, if somebody is designing a part of a conveyor system on a work line, and they're an employee, but they're a PE, would they have to stamp a drawing of a, say, conveyor system or whatever?
In my opinion, yes.
Okay.
We'll find out more as we look at this from a legal, but to me, it appears to be that if you're a PE, you have to stamp and sign stuff. They can go get a non-PE, since they have an industrial exemption, to do that same task, and industries often do. Industries often have people that are non-PEs doing that task. Well, I thought so. Did we ask for that?
Why don't we ask for it?
Did
I
we
think
ask-
we do need it.
Did we ask for that or not? Don't know if I
The question, here's
Your previous statement.
here's the broad question that we need legal help on.
Okay.
If a registrant does engineering work that meets the seals exemption laws and rules, is the registrant required to seal that work?
Yeah,
That's a pretty simple question.
Yeah.
And so I think we would like to know what the legal opinion of our laws and rules is on that, because there's not enough here to tell us definitively. And I think it's got pretty big
It's got
repercussions.
huge
It's like Kathy said. There are a lot of industry people out there. I promise you, they have PEs on staff and they're not having them stamp anything. It's like, put that seal away. That does not apply to
They're
our
telling you we're
workplace.
exempt. Yeah.
Well,
We are exempt. Yeah.
But I think I think the industry's exempt. I don't think the registrant's exempt, because they're under our laws and rules. We certify them, we fine them, we do everything else to them. They have
only
to.
do that when they do work that is
Which is all this work right here. All original sheets of bound and unbound and all reports. That's the work they're doing. Whether they're doing it in an industry setting or not, that's the way this is written. Now, we may have some caveats out there that say different than that, and maybe that's the case. But if somebody is registered to this board, they're under this board, and under this board's
Okay, so that's our question. And the exemptions there are seal exemptions that are described in the laws, and there's also the industrial exemption as part of that.
Did you think this was going to be a boring?
Okay.
I was about to say, y'all are over here making it too easy for
I know,
me.
that's it. Okay, so that email, we're just not going to answer just yet.
That's correct.
Until we
That's correct.
okay.
We knew we couldn't just
I
throw
know.
it out there with quick answers, so, okay, I'm good with that.
Okay, the next thing, Freedom by Design
What
project.
are we going to do
let's
with
not
that?
answer
Wait
any
until
of it.
legal tells us what.
Yeah, let's not answer any of it. Just tell him he's taken an hour of our discussion. We don't have any idea.
Have an answer.
But we got an idea,
And that
but we
person's
don't have
welcome
the
to
consent.
watch that you debated it
Yeah.
very heavily, so they'll understand perfectly. I think the next item's on page 41.
Right.
This is something I believe that only Mr. Campbell and I saw. It's from it's from NCARB, actually, just asking, or did you see it as well, Ricky? I don't
I'm so
remember.
glad to say that I did not, but I
Okay.
said that before, and I did. So,
They're asking for, I guess, assistance and reaching out to us to see, this is regarding their students in particular. So I'll let you take a look and see if you can guide me. Do you think page 41, I apologize. So we're almost at the end of this, if that gives us hope. Are under the B engineering items for discussion, and on page 41 and 45, yes.
I get this? Well, it says .duo. I wonder what that means on my email address.
It didn't get to you then, I bet you, if she sent it to.
rgc.ca.com .duo or .dup.
I bet you didn't, if this is the first time you're seeing it. So I just figured we'd look at it. If the board has any idea, suggestions on whether we want to work or can, we can respond. If not, the last item that we have, we've sort of already touched on decoupling, and it's your 10 points that Ricky did send. Have we done anything like this before? Helped encourage?
Here's what she needs to
Okay.
be referred to.
Okay.
They probably need to be referred to the local chapter of TSPE. There's a pretty active group that does, they've got, what's it called? Anyway, they do the water, they've got several projects that they work with local schools and different, that robotics, they're involved in the robotics programs. They're involved in all kinds of STEM activities. And this is at the Sarah Green Magnet School, I think. Yeah, whatever. I would have her reach out to the local chapter of TSPE and talk to them about that, because they do. Yeah.
Yes, it's 11
It's an outdoor classroom thing or something. So, I mean, again, they've got different people that have done stuff like that in the past, just service or project work, and I'm sure Nashville.
Perfect. Okay, that takes care of that.
okay.
On page 43, Ricky, this is your 10 points, 10 reasons to get your P. We've sort of, 5, I'm sorry, where did I get 10?
You
Oh,
remember when we
10
just made the
Yes.
that's the same exact
Same
stuff pulled off the NSPE website.
And we've sort of already touched on the decoupling and everything, so unless there's something that strikes you all here on this piece, we can leave it for tomorrow's conversation.
What's the decoupling? Where is that?
It's not the decoupling, it's the 10 reasons to get your
Or
PE.
the 5 okay.
5 reasons.
Well, all I was going to say about that is that I spoke to a bunch of students at Christian Brothers University in Memphis, and with 3 other PEs, and it was really the best session that I had been a part of. As far as that type of thing, I think that the students actually, a whole bunch of them stayed awake, and they were bribed by getting partial credit and all that. But one of the guys who spoke is this IBM engineer who has just an incredible career. He's been working on the artificial intelligence for IBM, and just some huge stuff. Was so gung ho about people being PEs and this is a big industry guy. I mean, this is somebody who meets the industrial exemption, and the evidence that he was given that why everybody needs to be a PE, every engineering graduate needs to be a PE, was incredible. I mean, he was just so compelling. And this is just one of the things he sent. This was a short one. I didn't want to flood your inboxes with other things, but he's like still sending them every day, and they're fantastic. These 5 points here. So I've got a bunch of them. All I'm wanted to say is if you other members of the board, if you want material like that, if you're going to speak to students, I now have a lot of it.
Good,
I've got a whole lot of it
All right.
that I can send you for your consumption and let you wade through it. But I didn't just send it all to Roxana because I wanted her to at least look at my emails when I sent them. So anyway, he's got a bunch.
Good.
Okay, so that takes us to the Southern Western Zone interim meeting.
Yes, and this came in either this morning or yesterday, so we literally had it at the last meeting minute, just because I knew we were going to talk about 2019 dates, travel, what everyone is wanting to do. This is for the Southern Zone in May, and I think we've got to give them a count of who would be going by February. So I thought I'd put it here for us to discuss and decide on the 3 members going. And then the August meeting, obviously, is their annual for the NCWS.
Is the zone meeting.
Yes, and it is in Idaho. We'll need to register and have everything by Wednesday the 13th. 3 board members are funded by NCWS, and I believe I would be funded if I'm not.
I see. So we need to decide now so we can go ahead and.
And if we're interested in going, yes, who the 3 would be, and then the annual one we know is in August. We can decide, and we can wait on that, but we can put it tomorrow on the record and say that 3 funded individuals would go to each one of those. That's what the board wants to do.
But based on my calendar, that my niece is getting married on the 18th, so that
Southern Zone, you'd be out? Okay.
I'd have to buy a present if you didn't go to the wedding.
if I didn't go to the wedding, I would have to worry about physical harm.
You have to buy a whole lot more than just a gift.
I have to buy a divorce attorney.
Okay.
That doesn't mean I'll be
I mean,
emotionally engaged in the wedding.
I think the only, I mean, I can go. I think I've gone to the last several, so I'm certainly, probably other people need to have first shot at it. So,
Well, I think if you 3 can go, or Steve,
I mean, that's what I'm saying. If Steve and Kathy and Alton can all go, I've probably been to more recently than they have. I don't know. I hadn't missed one in a while. I'm not at all. I would love to see that. I just don't want to be selfish.
Right. I guarantee you, if it was in Jamaica, you'd be all over it.
I passed on the luxury
Would not be
thing.
going to Jamaica.
Right. I passed on that. God, that's my buddy.
Okay, so Southern Zone, sounds like, can you make it?
I think
Alton?
so.
So we can shoot for that, and if something comes up.
I've
we can
texted my
change it.
wife to make sure I
Okay.
can make it.
Okay.
Not assistant, my executive.
Your CEO.
Well, do we want to?
I can go, yeah.
Okay, so we want to offer it to Steve. If Steve can't go,
Absolutely.
I can go.
Then you can
Wait, we have 3 funded plus the executive
Plus the
director?
executive director, if I'm able to go on that date, and I'll look.
Are the 3 funded by,
Yes.
and there's a prohibition against the state funding?
I
an
believe
additional-
from the last meeting, we just sent the ones that are funded by NCWS.
Let's ask the question
Now,
if we can take.
we can ask if there's interest in going. I think then the debate is the annual meeting more worth the bang to go to, or the Southern Zone, or are they completely different and both worth addressing? I've made it to the annual meeting since I've been on the land surveyors, and then with this one, and you get a lot out of them, but I do also from it can say that they recap what happens at the Southern Zone meeting, so I would be fine just going to the annual one personally, but
I found the Southern Zone one to be very, very useful. Me too. I mean, I would have previously said annual's enough.
Right.
It's all the same
Right.
stuff, just rehash.
okay.
I think two different things are happening, though. The Southern Zone gets you into the issues that will then be voted upon at the national. So it makes for a better annual meeting if you've been to the Southern Zone, or really make a good.
I agree with that. That's my point. I think it's important that we go to the Southern Zone meeting. And I agree with what Kathy's saying. We've got a lot of other states there that have very, very, very similar situations and issues and problems and concerns that we have.
What are we saying? We've got 3 that are funded by NCES, and the state will only agree to send those 3. Is that correct?
At the last meeting, that's what we did.
That's what
It's
happened
just
at the
stuck to
last
3,
annual
right.
meeting.
But
We
you all
didn't
can
ask.
discuss it. I mean, we can,
We can request
Right.
funding for a fourth.
correct.
Yes.
I'd like to officially ask that we request funding for a fourth.
Okay,
Yeah,
okay.
that's fine.
Now, for the annual meeting, are you going to be able to, both you and Ashley?
That's a good question. I really want Ashley to go to one or the other if we have to split up, and can't go together. I think a big concern with the travel is now how legal is expensed. So just from a being conscientious of expenses, in general, legal is going less and less they need to, and in this case, I think it's huge for her to go because it's 2 programs and she's brand new. But for a repeated attorney that had been, the question would be, is it really necessary? Because it is 4 or 5 days and all of your travel is then expensed, your time is expensed to the program instead of just the hours here or there. So it's huge. But in this case, Ashley, definitely needs to. And if the board is of the opinion that the Southern Zone would help her, I'd say she'd go to the Southern Zone first because it's sooner.
I think that's probably a good plan, is to try to ask, ask for the 3 funded and 2 not funded, and one of those being Ashley and one being Steve. But if we get 4,
Be Ricky or Steve.
Well, Steve, but if we get all 4 of you to go, plus Ashley, I think that to me that makes a lot of sense.
I agree with that.
Yeah. So just ask for the 3 funded and 2 we fund as from the board coffers.
Okay.
Plus, this is my last year, so I don't need to go to.
Okay. All right. So the last topic I know about is one I think we've all been waiting for, really, and just can't wait to do, is to elect a new engineer committee chair, I think.
I got something else I'd like to add. That's okay.
I'm just kidding.
I just didn't want you to end the meeting before I asked my question. So, but we can do your.
No, go ahead and ask your question.
Okay. Well, my question is I would say this all in the hypothetical, but it's really not. It's public information. So, a few weeks ago, there was a local engineering firm owned by a group of local engineers that it was made known publicly, front page news, that they were being investigated for potential conflict of interest, et cetera, et cetera, et cetera. And I'm just curious as to how does that.
Not only conflict of interest, but unethical behavior.
I wasn't going to go into all the details. Let's just say it wasn't good, and it was bad stuff, and it's had continued ramifications. So what's the process, or is there one by which that would automatically become a case that, or I mean, it's not like nobody needs to turn them in. It was on the front page of the Tennessean. If anybody's paying attention, it's right there. So. does that automatically become a
Well-
complaint or how, or a case or whatever that is? Or
It
does
doesn't
somebody act-
automatically. Somebody has to open the complaint, and that can be, board members can open it. It can be all the information sent to the office, whether directly to Ashley or to myself, saying, I'm not able to open the complaint. Here is everything. This needs to be opened. As we've discussed before, it's not really anonymous, but it can come in for us. The office doesn't just decide, we don't go out searching for it, but when we see something, if we're not sure what it is, we could discuss it. I don't think anything has opened that I'm aware of in the last week or two.
Well, it only came out, late last week?
It was a couple of weeks ago.
I just saw it late last week.
That does not ring a bell as an open complaint. So it would come from a member of the profession that saw it, read it, knew these are violations at all levels, and opened it, turned it over for somebody in the office to open, that kind of thing.
I mean, we're sitting here talking about what constitutes a document that has to have a seal on it, and yet there's a front page article about an engineering firm that's being investigated for unethical behavior, and I think that's the least of what was brought up. So it almost seems like it would be dereliction of duty for us to, as a board, to ignore that.
And is it all about the firm, or the individuals are named out, called out, who are licensed?
There are individuals
Okay,
named.
so
The firm is
that's-
called out, and individuals are also named. Actually, the result of a private investigation. Somebody hired a private investigator.
There was a case within the last couple of years that hit newspapers and TV that were board, when the board found out about it, the board opened a case.
I mean, as board members, you read it, I read it. If y'all weren't in Nashville, you didn't read it. But, I mean, you couldn't miss it. If you're in our industry, I'm sure everybody knows about it. It just seems like it would be, again, me choosing to go and ignoring it as how can.
But at this point, I think they're allegations. I don't think there's been any proof or anything
I'm not saying
filed.
they've done anything. I'm just saying it's out there as an investigation, which I have no idea if it is what would rise to the level of a criminal investigation, but we don't, I mean, that's a big deal if we're talking about unethical behavior relative to being a registrant.
Also, when we've had a case to look at, but it went to litigation, we've kind of opted to say let the litigation happen, because they'll have a lot more discovery and detail. And I don't know if that is a case where that can be sent in to the board, but just like with a monitoring status.
It'd have to be open first, and board members by all means can open the complaint. It actually now, when you open it online, it is the live complaint that eventually, I sent you all some statistics. It opens that day. There's no scrutiny on what opens, what doesn't. It would be opened the minute you open it, and if you're not comfortable opening it and everything is sent in, we can definitely review it, but realistically, we avoid anonymous complaints, so anyone can open it.
Staff can open a complaint, but you try
We
to
open
avoid it.
administrative complaints.
Administrative
Yes,
complaints.
we do. That's how it would be viewed, as an administrative complaint. So, and other industries have done that, just sent articles saying, this shop had drugs found and this individual, and here's the report, because you may or may not have it, but here's everything. Here it is. And so,
Well, it continues to have widespread implications in that there was a solicitation on the street that was canceled last week because of this ongoing investigation. So, I mean, it's not over. I don't think it's over. And the allegations are pretty bad. I just want to know how.
And the evidence is pretty compelling.
Does that answer your question about how that would work? Okay. Okay, well, I think we got to nominate
I'd like to nominate someone. Quick. May I nominate Alton?
Wait, I
No, I beat you to it. Beat you to it. Beat you to it.
Second.
Oh, good Lord. If appointed, I will not serve. How do you say that? What is it?
You have to just say yes.
Oh, my Lord.
You're, okay.
All those in favor? Okay.
Steve's
Don't
not
mad
here.
at me.
Well, here's the
The ayes,
deal.
we need one more aye.
Steve's not here, and I may not be here next year, right, at this time. So you need to.
Usually when somebody's not here, they get appointed. It's the way that works.
Kathy's working on definition, so it makes sense.
I'm going to vote aye if
Not
you will
talking to
accept
Frank.
that.
So, there.
Okay. Yes, thank you. I'll be honored and nervous to serve.
Let me ask you a question on that. What if Kathy talks to me since I'm not working on definitions and I talk to Frank?
Board member.
I'm not working on definitions.
You're a board member.
Yeah, it doesn't matter whether you're working on the definitions or not. Because you're a member of the board, you can't consult without it being a public meeting.
I've got it written down to
Okay,
question it one
I
more
just
time.
think it's in the, not what our training said, but whatever.
Okay. All right, any other topics that we need to cover? Okay, do I have a motion to adjourn?
So move.
Second.
All right, all in favor? Aye.
Thank you. That's good.
Thank you.
Thank you, Ashley.
Yeah, no problem.
I mean it when I say you're amongst friends.
I believe you.
you're
I
with
feel
us.
like I'm amongst friends.
Yeah. It's just, these are tough issues. We try to do the
They
best we
are
can.
tough issues. Like I said.